Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is our podcast, I Now Pronounce You Divorce, where each week Rebecca, Dan, and I talk about issues that we see our clients going through or questions that potential clients have when they call us. This week, we're going to talk about something that not a lot of people think about. You know, when you're going through divorce, it is a major life change. And I think everybody understands it's a major life change. There's a lot of stuff going on. I need to focus on, what my children are going to be doing. I need to focus on where I'm going to be living. I need to focus on my mental health, my physical health. But another thing you need to really start focusing on as you're going through divorce is your financial future and your children's financial future. So with our clients, what we talk about a lot is really undertaking a deep dive into estate planning during the divorce process that ultimately leads to the creation of a new estate plan after the divorce. And a lot of people don't realize that, I am guilty of this. I don't have a good estate plan. I don't have any estate plan. But you don't realize that after you're divorced, the estate plan becomes more necessary. And tell us why, Rebecca.
Sure. So I've seen a number of really sad cases, unfortunately. What you don't necessarily realize when you're first initiating a divorce is that you are still legally bound to this person until you get that final order where the judge signs off on the paper and says these parties are divorced. That other person's your spouse that whole time. And so if something happens to you, they're going to inherit your estate and vice versa. Usually when we're going through a separation and we're trying to split everything up anyway, that isn't what you want to have happen, right? And so starting out with an understanding of what we have, what the laws say, if you have no estate at all, this is what the laws say. And then what would your goals be? And then we can start tailoring it from there.
And you brought up something very interesting. Even when you just start thinking about divorce, a lot of us forget that we're still married. So Dan, can you kind of talk to us about the implications of, hey, I've had the conversation, I moved out, but that you're still married and what that really means for the real world impact of what's going on?
Yeah, sure. It can be a little bit tricky because you think, now that I've made a decision, I want to separate divorce, I can do what I want because I'm no longer, as we've been talking about, obligated to this person. But that's not the case. And it's so essential and imperative that you communicate and speak with an attorney because there's a lot of risk involved, especially in certain states, at least the ones where I'm licensed in, that there's waiting periods. And as soon as you even think about filing for divorce, there's like stopgap measures essentially that are in place as you cannot do anything. Everything has to remain status quo. And if you violate that, you could be subject to sanctions and additional penalties. And you want to be able to put your best foot forward with the court. So you don't want the judge thinking that you're trying to do something surreptitiously or underhanded and trying to take advantage of a situation. And a lot of times when I've had clients come in and talk to me as far as I'm ready to move forward, but I want to take my spouse off the will, or I want to amend my trust, and we have to have those tough conversations that, well, we can get there, but we need to first file. Then we need to have conversations as far as what does that look like? What are your assets as far as what Rebecca was saying? And then we need to discuss, all right, so what does that look like to you? If we move forward down this path, what are you wanting to keep in the will? What are you wanting to keep in the trust? And then who's going to be the executor? Who's going to be the trustee? What does that look like to you, meaning the client? But then also you can use that in negotiations too. Another thing that comes up in meetings with clients is beneficiaries. Who's the beneficiary of your 401k? Who's the beneficiary of something would happen to you, at work? And these are things that in most states have to remain the same until the actual court signs off on the divorce. So you can pre-plan and get an idea of what that looks like. But the number one mistake that I see clients make is removing their spouse from certain items, which could be a beneficiary, or take them out of the will, or change in the trust. And because a lot of times you have to have consent of both parties, but also those are negotiating things that we can use as far as trying to resolve your case in an efficient but in a favorable manner for you.
Mm-hmm. Yeah, and you made a great point. You cannot just go down, cross out your soon-to-be ex-spouse's name, put a little squiggly signature next to it, and say, "Look, I'm done." I look at estate planning. First of all, the term estate planning is somewhat stilted. It's a catch-all term that I don't think anybody really knows what it means. Estate planning to me sounds like the Biltmore estate, and they had to create trust and put this land in trust so that the house would last forever. But having been through a medical procedure, estate planning is as simple as a medical directive. And so what I was saying is I look at it as being bifurcated. What you need to do to protect yourself during the divorce and what you need to do to protect yourself after the divorce. So Rebecca, can you walk us through, I kind of said a little bit like what you need to do during the divorce and, bring in that medical directive is part of this.
Yeah, absolutely. So when you're first getting started with a divorce, you need to be aware of what documents you already have. And if you and your spouse have already done a will or a trust, you probably also did powers of attorney and advanced medical directives. And most likely, you named your spouse as the primary agent on those documents. So, this person that you no longer want to be living with, that you no longer want to be financially tied to, could potentially step in and mess with your bank accounts. They could potentially step in and make healthcare decisions while you're unconscious or incapacitated. And that isn't what you want to have happen. So if you have those things in place, you need to first revoke them and then put a new set of at least an advanced medical directive and power of attorney in place where maybe you're naming a friend or family member, a parent, a sibling, someone else like that that you can trust as you're going through this. They might not be your agent forever. They might just be your agent until we can figure some more things out along the way. But you want to put that kind of band-aid in place and make sure that your spouse doesn't have more control than what you would want them to have. Because we've seen, unfortunately, situations where people are going through a divorce and somebody gets into an accident or somebody has to have a medical procedure or something else along those lines happens. And now everything defaults to that other spouse who may not even be local anymore. And most likely doesn't have your best interest at heart in that exact moment. So we need to make sure that these things are revoked and something else put in place to replace them so that you're protected as you're going through this process.
And you use this big word revoked.
Mm-hmm.
How do I go about revoking a medical directive that I may have forgotten existed?
It's pretty simple. You write it in the first line of your new one. I hereby revoke all previous medical directives that I've ever completed. In Virginia and in a lot of states, I'm sure they have the same thing. But in Virginia, we have a registry, a statewide registry for advanced medical directives. So once you've completed that new one, you go onto the registry, you scan it and upload it. And that way, if you're ever hospitalized somewhere unfamiliar or, you forget where you put your copy or whatever it is, you're able to access that information. And just having the new date, this year's document is going to supersede last year's document, right? The most recent one is always going to be the one that controls because the newest one revokes all of those old ones.
And the reason I ask that is because we may not remember that we did a medical directive. Even as we were talking, I was thinking, I had a pretty major surgery. The hospital made me do a medical directive. I was younger. I was being flippant with my mortality. So I wrote a medical directive. To me, that was a joke. So my parents had to vote 50-50 to pull the plug on me. And then they had to, if they decided to pull the plug on me, had to consult with a priest in a different state to do it. I mean, it was just absurd. But the reality is I've never written another medical directive. That is my medical directive that's on file right now, making my parents have to jump through this hoop that I thought was hilarious 2 decades ago. So Dan, can you kind of walk us through on what you should do? So you might have these documents sitting out there. You might not have these documents sitting out there. But there's also a power of attorney that Rebecca touched on. Can you kind of walk us through those?
Sure. As Rebecca was talking, I was thinking of this case that I had where I was representing one of the spouses and they forgot, speaking of everything we've been talking about, that their other spouse had that authority. And then my client passed away because the other person said, oh, well, they don't want to be on life support. So go ahead and let's just term, but not having the best interest of the estate, except for a personal interest. And from that moment on, as practitioners, we always need to make sure, even if we're inheriting a case, we're doing the due diligence of asking these questions because we need to know. And so I think just for a good practice, when a client comes in, when we're going through the property and the debt, this is something we cannot overlook. To me, it's property. It's, okay, what is your power of attorney look like? Who's going to make those decisions when it comes to health? Who's going to make those financial decisions if for some reason you become incapacitated? And who's going to determine if you're incapacitated? Is it just one doctor? Is it two? Do we have to have a team? And then who can you have? Do you want to have a team of individuals that you think has your best interest? And these are discussions you want to have with your attorney, because you want to make sure as you're moving forward, the individual or individuals that you select not only have your best interest in mind, but what if there's children involved? What does that look like? Who's going to be the beneficiaries of some of the assets? And so we just want to walk through what that looks like. But then as we're going through the case, not only do we need to identify, but we need to review these documents with our clients too, just to make sure that they are current, and that maybe there is a client that has an outdated one that you have, Charles, that may have something they thought at that time sounded good. Oh, well, I have this good friend of mine that will have my best interest. And as you talk to the client, maybe they haven't talked to that person in like 20, 30 years. And so one, be a surprise to that person, they get the phone call. And then two, it's, well, let's have someone that's a little bit more closer to you, that in the current situation that you trust, because there's so much at stake. And we want to make sure that as the clients, you hear the acronyms POA and things like that, but what does that really mean? And make sure the client thoroughly understands the ramifications and what could potentially happen. What is that risk if something were to happen to you? Of course, we don't want that, but we have to plan for the future. And as lawyers, we're always thinking of worst case, best case scenario and walking the clients through that. And part of that process is really identifying when we're trying to resolve your case, we have a medical director, we have a power of attorney, we have a trust, we have a will. Let's take a look at what all those documents currently are. What do you want them to look like? And then let's identify what we talked about earlier, other items that you have beneficiaries on, because those things get overlooked as well. I've had a lot of clients come back from other firms to where they forgot about these documents. And a lot of times it's a little harder to change those after the divorce, because depending upon the jurisdiction, some courts consider that property, and if that hasn't been changed, then the only way that it can be changed would be by order of the court or consent of the other side. And afterwards, my experience has been the other side is going to say no, or in exchange for something else. So we want to try to prevent a lot of these pitfalls.
And one of my favorite words, it's a prophylactic measure, right? We're trying to protect you through this very difficult process from everything that can happen. And I brought it up. I was flippant about my mortality when I was younger. I probably still very much so am. But we've had clients across the age spectrum who have run into issues, right? This isn't just somebody passing away. This isn't somebody that's just put on life support. This is getting in a car accident and having to go to the hospital and getting put on life support. This is, I was reading a book the other day. I think it's called He Said, She Said, and it's about a person that was imprisoned during their divorce. We have false allegations of actions against the children. Well, guess what? When they're in prison, the power of attorney kicked in. And so there's so many instances beyond just passing away of old age, like a lot of people envision it wrongly, that these things arise. And, Rebecca, in your experience, is this a minuscule percentage of issues that arise that these become enforceable, or enough of a percentage that we would have a podcast about it?
Definitely high enough that we would have a podcast about it. The sad thing is, though, that even if you just see one of these cases, it's usually a huge amount. It's so unjust. It's so painful that you really want to make sure everybody is protected, because you don't want to be that one out of however many cases that we've seen where just everything goes in a direction it shouldn't have. So I was talking earlier today about the rules in Virginia say that basically whatever a judge says from the bench is not an order until they write it down, right? That's the rule. And so a judge might say, you're divorced, but it doesn't really happen until they sign that piece of paper. And so one of my cases that led to us doing estate planning is I had a client who was the wife, and she had been abused by her husband. She was the one that had all the property. She had real estate, she had retirement accounts, and not a ton, right? But she had some property. And so the judge awarded her to keep everything, for them to be divorced. Everybody's going to go their separate ways and be done. And in between that order happening in court and before the judge's signature actually hit the piece of paper, my client passed away. And she didn't have any children, and all of her assets went to her husband because he was still her husband at that point in time. When you hear stories like that, and she was younger and she didn't have medical problems, and she did, there wasn't any sort of major thing that happened. She just very suddenly passed away. When you hear a story like that, it sticks with you, right? You never want that to be the result of a situation like that. It's so drastically unfair, and it's so easily preventable. And that's why we want to make sure that all of our clients are completely covered, from point A to point Z, the whole way through the divorce, and then hopefully beyond.
I was thinking about the question of how many times do we actually see this when I asked you. I would say that we see it, at least in about 10% of all of our cases every year, that there's some form of the medical directive or the power of attorney that becomes active. And what I mean by that, something happens. Power of attorney is a very powerful thing, right? Somebody can go to your bank account and drain it. And, the book I was reading, the guy was put in jail because of his false allegations his wife made. And as soon as he set foot in jail, she went and drained all his bank accounts because he hadn't changed his power of attorney. I want to thank both y'all for joining me for part 1 of talking about estate planning during the divorce process. Next week, please join us for part 2. We're going to talk about the necessity of estate planning after the divorce process, especially if you have children. So we look forward to talking to you then.
Thank you for joining us this week on I Now Pronounce You Divorced. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.